Good morning, this is your Kelso Report for Friday, October 26th, and I'm your host, Clark Kelso. Our cases today include an anti-SLAPP motion filed in response to an attorney malpractice claim, a battle between insurance companies over equitable contribution arising out of decade-old construction defect litigation, and the question of how many punishments a defendant can receive for a single indivisible course of conduct. We begin with the anti-SLAPP case. Now, as you know, I've been critical of the apparent trend towards giving California's anti-SLAPP statute an overly broad interpretation. The anti-SLAPP statute is designed to protect against lawsuits that are brought against someone in retaliation for their exercise of First Amendment rights of speech and free expression. That's a good policy. My concern has been that the right to bring a lawsuit is also a protected activity under the First Amendment, namely the right to petition government. And anti-SLAPP motions can themselves burden the First Amendment rights of a plaintiff in the name of protecting the First Amendment rights of a defendant. Fortunately, in the last couple of months, we have seen a number of decisions now recognizing limits on anti-SLAPP motions, and we have another such decision this morning. In Chodos v. Cole, an attorney who was sued for malpractice in connection with the settlement of a marriage dissolution filed a cross-complaint seeking indemnification against other attorneys who had reviewed and approved the settlement. Well, those attorneys responded to that malpractice action by filing an anti-SLAPP motion, alleging that the basis for the indemnification were oral statements that constituted First Amendment protected activity. The Superior Court agreed and struck the cross-complaint. But the Second District, I think, correctly reversed, holding that as a general matter, a complaint alleging attorney malpractice, or in this case indemnification arising out of attorney malpractice, is not subject to an anti-SLAPP motion, because the basis for such a malpractice complaint is the attorney's breach of his or her duty of professional care. And that breach of care is not protected activity. As the court explained, quote, "We deal with a claim based on a breach of duty, malpractice, and not with a claim based on direct communications concerning a lawsuit," close quote. Next case involves a dispute among insurance companies. When a large construction project goes awry because of construction defects, it usually spawns a good decade or so of litigation. This is because the parties first must resolve the underlying construction defect claims. And then, if there's liability at all or a settlement, there usually is follow-on litigation just between the insurance companies as they try to work out how much each insurance company is responsible for contributing. We see this usual scenario play out in St. Paul Mercury Insurance versus Mountain West Farm Bureau Insurance, where the Second District resolved claims for equitable contribution between the general contractor's insurance for the construction of a Four Seasons hotel in Jackson Hole about a decade ago, and the framing contractor for the project. The issue in the case was that the insurance company for the framing contractor believed it had discharged its duty of defending the general contractor simply by paying into the settlement of the underlying construction defect action, even though the company actually did not provide a defense. The Second District disagreed, and as a consequence, the framing contractor's insurance company found itself in the uncomfortable position of having the burden of proof in the contribution action shifted to it to prove the absence of actual coverage as an affirmative defense. And in addition, it forfeited its right to challenge the reasonableness of the defense costs and the amounts paid in settlement. In other words, when an insurance company doesn't fulfill its duty to defend and sits on the sidelines in the underlying litigation, that company should expect to be put behind the eight ball in the subsequent wave of litigation among the insurance companies for equitable contribution. Finally today, in Section 654 of the Penal Code, the legislature has expressed its opposition to having multiple punishments for a single indivisible course of conduct. Section 654 is necessary because a single indivisible course of conduct can often be the subject of multiple charges and counts, which can exaggerate the defendant's length of sentence. To determine whether an indivisible course of conduct exists under Section 654, courts are supposed to consider the intent and objective of the actor. If all of the charged offenses were incident to one objective, the defendant may be punished for any one of such offenses, but not for more than one. As noted by the 2nd District in People v. Nunez, the process of determining the defendant's intent and objective can be especially confounding in cases where the defendant was legally insane at the time of the offenses. According to the court, such a defendant is incapable of knowing or understanding the nature and quality of his act, or if he did not know or understand, he cannot distinguish, or if he did know or understand, he cannot distinguish right from wrong. But such a defendant may still have an intent and objective. It is just a little more difficult to ascertain, close quote. Well, the facts of the case show that the defendant had escaped from an inpatient mental health facility and one day later struck the victim with a hammer as part of an apparent effort to steal the victim's Grand Cherokee. Voices in his head told him to take the car. The trial court committed the defendant to Patton State Hospital for a maximum of 17 years, 15 years for carjacking, plus 2 years for assault with a deadly weapon. Well, on the facts, the 2nd District held that the assault was incidental to the carjacking and was therefore subject to Section 654's prohibition against multiple punishments. The court reduced the maximum commitment to a mere 15 years. Well, that's it for today's Kelso Report. Have a good weekend and a great day in the law.